And Andrew Weissmann, so give us your analysis of the steps that Alvin Bragg has taken to this point. What could be inside this 30-count indictment now that we have the approximate number? What does that tell you, if anything? And whether you think that the judge could even issue a gag order or some sort of order about social media, the threats and the angry statements that have been coming for the last 18 hours now.
So let me take that last point first, because I think it's so important. You know, I keep on thinking about the Roger Stone case, which was brought by Special Counsel Mueller, where Roger Stone posted a photo of the district judge, the eminent district judge, with some crosshairs in the photo. And she did a number of things in response, held a hearing, found him not to be credible, and restricted what he could say. So Donald Trump, I think, has walked back or tried to walk back some of what he's been doing, but he is not going to enjoy the same First Amendment rights of speaking out. If he ends up saying things that are inciting violence, the judge can severely restrict what he's saying as a defendant out on bail. Because that judge now has authority over him. That's going to obviously annoy Donald Trump to no end, who's not used to having somebody telling him what to do, where the penalty for that can be additional charges or even going to jail. So Judge Merchan will have that ability once Donald Trump is arraigned. I'm also not that concerned about him showing up, because if for some reason he insists on being extradited, you know, he's facing a rape charge in a civil suit at the end of April in New York. So he really needs to show up for that, or else he will default in that case. So there is sort of a backstop on when he does need to be in New York to face these charges. So that could be in the back of his mind about why there's really no reason to be extradited. And I think what's going on with Alvin Bragg right now is really keeping his head down, getting to the arraignment, figuring out exactly what his position is going to be on bail and the appropriate restrictions to make sure that there's no violence. I am confident that the NYPD, the Secret Service, the FBI are very focused on security and making sure that people on the grand jury, that people, court officers, that prosecutors are completely safe, as well as all of downtown Manhattan. This is an area where obviously there's a ton of law enforcement here with a lot of experience to make sure that nothing's going to happen.
One other question. Do we learn anything by the number of charges? Does that tell you anything about what kind of case this might be?
So it doesn't, because I know a lot of people have thought that there's been reports of maybe 30 or so charges, and that maybe this could be beyond the so-called hush money payments. But it is possible for these payments to be charged, and that to be the essentially the gravamen of the case, because you could have hush money payments and false filings in multiple locations, and each of those could be a felony and be charged as a misdemeanor. There obviously could be a conspiracy count going back to the events with Karen McDougal. I do think that number doesn't really change the severity or the lack of severity of the charges. Is just a question of whether the the core of the offense is something that has tripwires that resulted in numerous laws being violated. So I still think we should expect sort of the hush money payments being the core of this indictment.
And Danny Cevallos, I want to play the initial defense we heard from Joe Tacopina, one of the attorneys for Donald Trump, this morning in his discussion on the Today Show with Savannah.
We do know it centers around, a legal, very common confidentiality agreement that was signed years and years ago with Stormy Daniels and between her attorneys and Michael Cohen. The only other precedent that's even remotely close is the John Edwards case, which was prosecuted by federal authorities because it was a federal election. It was prosecuted because there was a donor involved, as opposed to using personal funds like here. Somehow a state prosecutor who doesn't even have jurisdiction over the federal elections is prosecuting a case. This was a personal resolution for a personal matter that would have been made irrespective of the campaign.
Danny, as a defense lawyer, what do you think of that defense?
He's got some points. There is definitely enough for the indictment to get to probable cause. But this is a defensible case, and people need to be prepared for that. And Joe Tacopina has been on the air making his points, a lot of them that he got from Mark Pomerantz's book, and he essentially says as much. But this is a defensible case because there may be an issue as to whether or not New York can use a federal election law violation as a predicate. They won't be prosecuting it so much, but they kind of will, because they're going to be using it to bump up what would ordinarily be a misdemeanor charge to a felony. The falsification of business records is a default misdemeanor. That case is a lot stronger because it's document heavy. We've seen the checks, we've seen the documents, we've seen the agreements between David Dennison and Patty Peterson, or whatever their phony names were. So we know the documents are out there. That's probably the easier case to make the misdemeanor. However, in order to bump it up to a felony, they do need that falsification to be in furtherance of or to conceal some additional crime. Well, what is that crime? If it is a federal election law violation, then it's going to be an interesting legal issue whether or not New York can even use that, whether or not they have to prove it, or whether or not they can prove it, because it is federal law. And then expect the defense to move to even throw that out. And if they do, if all those felony counts get thrown out and it's reduced to a misdemeanor, that becomes a political win for the ex-president, because now he's defending a misdemeanor case. And you better believe he's going to plant a flag and say this is a political prosecution because these are rinky-dink misdemeanors if that happens. Not necessarily going to happen, but that and some other points make this a defensible case. And then just one other thing, and Andrew mentioned the extradition. Arguably, the most controversial thing in the last 24 hours out of a presidential candidate or a hopeful isn't Trump. It's Ron DeSantis saying that he would not cooperate, Florida would not cooperate with extradition. He has to know this is not an option under the Constitution when it comes to interstate extradition. It must happen. It's in the Constitution. He's not China. It's not Canada. It's not another country. Florida must extradite to New York. But it's probably a mood issue because Trump's going to show up no matter what.